This is English shorthand dictation number 336 and the dictation speed is 100 words per minute. Ready? Start. We have gone through the impugned judgment and order passed by the High Court as well as the findings recorded by the learned trial court confirmed by the First Appellate Court. We have also considered the deposition of the plaintiff witnesses, which were elaborately considered by the learned trial court. From the deposition of the plaintiff witnesses, it can be seen that the plaintiff and other witnesses specifically admitted that the land in question on the land of the plaintiff was constructed in the year 1987. The plaintiff witnesses have also admitted that the retaining wall was constructed on the land of the plaintiff in the year 1987. Even according to the plaintiff and his witnesses, the fruit trees were destroyed in the year 1987. Even the cause of action pleaded in the suit was construction of road in the year 1987. Considering the aforesaid facts and circumstances, when the learned trial court held that the suit was barred by limitation, considering Articles 58 and 72 of the Limitation Act, and when the same was confirmed by the First Appellate Court, the High Court ought not to have interfered with the said findings of facts in exercise of powers under Section 100 of the Code of Civil Procedure. At this stage, it is required to be noted that it was the specific case on behalf of the defendants that the road was constructed with the help and consent of the plaintiff, which is established and proved by the conduct on the part of the plaintiff, mainly not raising any dispute till 2002. From the impugned judgment and order passed by the High Court and the substantial question of law framed, it is to be noted that the High Court has not framed any substantial question of law on the limitation or the suit being barred by limitation. The High Court has gone on general and broad principles. However, the High Court has not at all considered the real facts which are narrated here in above. Even the substantial question of law framed by the High Court also cannot be said to be a substantial question of law at all. Be that as it may, the fact remains that the road in question was constructed in the year 1987. The trees, if any, were removed in the year 1987. The retaining wall was constructed on the land of the plaintiff in the year 1987 and the suit was filed in the year 2003 and therefore the suit was barred by limitation considering Articles 58 and 72 of the Limitation Act. The impugned judgment and order passed by the High Court is unsustainable and the same deserves to be quashed and set aside. In view of the above and for the reasons stated above, the present appeals succeed. The impugned judgment and order passed by the High Court is hereby quashed and set aside. The judgment and decree passed by the learned trial court, confirmed by the first appellate court, dismissing the suit, is hereby restored. It is a matter of record that appropriate request for constituting an interstate river water disputes tribunal to go into the issues has not yet been made by the plaintiff state. However, the matter has been engaging attention of this court principally on the issue of the interim relief to be granted in the matter. At this length of time, when 19 years have elapsed, it will be extremely difficult to consider the matter purely from the perspective of grant or non grant of interim relief. During the last 19 years, various developments such as augmentation of water from the concerned river for various developmental activities, including the need of the people in the basin, have taken place. At this juncture, the matter requires to be considered in the light of the present day situation. Having considered the entirety of the matter, in our view, the proper course would be to relegate the plaintiff state to take appropriate proceedings as are open to it in law afresh, including approaching the central government for constituting interstate river water disputes tribunal or for any other appropriate remedy. We therefore dispose of this suit, giving liberty as aforesaid to the plaintiff state. At this stage, learned advocate appearing for the state brought to our notice that the parties have exchanged pleadings and evidence was placed on record. If said pleadings and the evidence are to be relied upon, the plaintiff state may take appropriate steps in accordance with law at any given stage. We have heard the learned counsel appearing on behalf of the respective parties at length. At the outset, it is required to be noted that, as such, there are concurrent findings of facts recorded by all the courts below on the readiness and willingness of the plaintiff to perform his part of the contract, which are not required to be interfered with by this court in exercise of powers under Article 136 of the Constitution of India. However, at the same time, what is required to be considered is whether, in the facts and circumstances of the case, the High Court is justified in overturning the judgment of the learned trial court as well as the first appellate court, refusing to pass the decree for specific performance of the sale agreement. At the outset, it is required to be noted that, as such, while allowing the second appeal and overturning the judgment and order passed by the learned trial court as well as the first appellate court, the High Court has not framed the substantial question of law which is required to be framed under Section 100 of the Code of Civil Procedure. Even otherwise, on merits also, looking to the terms and conditions stipulated in the sale agreement, the High Court has erred in passing the decree for specific performance, which was refused by the learned trial court as well as the first appellate court.